I didn't. If you want to find Professor Tsunoda's CV or resume, you can go Google it later. I think the more important thing is that she is absolutely the consummate lawyer scholar. She was the first woman hired at a major law firm in Japan at a time when only 500 people a year were being admitted to the bar. She also is famous for arguing the first sexual harassment case in Japan, including and many others after that. And I hesitate to say this, but in some ways, she is the Japanese Catherine McKinnon, and I mean that in the good way. She's authored several books about gender and law. And I also want to say, kind of on a personal note, I send my manuscripts to Japanese scholars a lot to get comments. And most of the time, Japanese legal scholars don't know how to comment on American scholars' work because their work is much more doctrinal. I sent my last manuscript to Professor Tsunoda, and I got back, I don't know, what did you send me, 10 or 12 typewritten pages, and things that were just, both from very large concepts to, do you not see this typo you have right here? It was extraordinarily helpful, and I really have never had such thoughtful comments from a Japanese scholar before. She is also one of ours. She is a former research scholar, a former Toyota visiting professor, and I'm happy that she's back home. So I'm proud to introduce Yukiko Tsunoda.
Good afternoon. Thank you, Professor Mark West, for your warm introduction. And I'd like to thank Center for Japanese Studies and the Law School Japanese Legal Studies program for giving me this wonderful opportunity. And before I deliver my prepared talk, I'd like to take a moment to acknowledge the enormous suffering of many Japanese due to the unprecedented earthquakes, tsunami, and failure of nuclear power plants. The topic of my talk today is domestic violence. Domestic violence and other forms of violence against women, such as rape and sexual harassment, are known to increase after a major disaster. As I will mention in my talk, women's groups are the ones that have been addressing violence against women in Japan. They work tirelessly with extremely limited resources, relying mostly on volunteer labor. After the disaster, they will be even busier, but they will receive little, if any, assistance from the governments and other mainstream relief organizations such as the Red Cross. Because of this, a group of activists and organizations in both Japan and the US are organizing a fundraising drive to help Japanese organizations who address the problem of violence against women in the affected areas. Right now, we are working out logistics such as how one can donate in US dollars, how one can use credit card, how about tax benefits, etc. If you are interested in assisting these Japanese women's organizations who desperately need additional resources to respond to and prevent violence against women in the affected areas, could you leave your contact information on this sheet? We, actually Professor Yoshihama in the School of Social Work, who is in this room, will contact you as soon as the donation system is established. Thank you. Now I'd like to begin to talk today's talk. I'd like to begin with an overview of the situation surrounding domestic violence in Japan. The concept of domestic violence was introduced into Japan in 1992 by Mieko Yoshihama, professor of the School of Social Work, University of Michigan. Then a PhD candidate of UCLA. Professor Yoshiyama and 7 other Japanese women, including myself, organized a research and study group and conducted the first ever nationwide research project. The results shocked Japanese society, which had long denied the existence of domestic violence. Following our research, grassroots women's organizations took up the issue of domestic violence and conducted similar research. Some local governments did likewise. As a result, social attitude toward domestic violence gradually changed, and finally domestic violence was recognized as a human rights violation and a crime. Women activists against domestic violence united and lobbied to establish a new law which prohibited domestic violence and provided victims, survivors with the necessary support. In 2001, their effort resulted in the law for the prevention of spousal violence and the protection of victims. In my talk, I called this law domestic violence law. Through the amendment, the domestic violence law has been improved gradually, although it still has its shortcomings. The law provides tools to prevent domestic violence and protect victims. For example, 1, the national and local public entities, prefectures, establish basic plans to prevent domestic violence and provide victims with the appropriate protection, including assistance to make them self-reliant. 2, every prefecture establishes spousal violence counseling support centers, which are instituted to work for the victims by providing them with the necessary information, counseling, guidance, and temporary protection in a shelter, and so on. 3, the court can issue 3 kinds of protection orders. An order which prohibits an abusive person to approach his or her spouse or partner, children, and the partner relatives for at least 6 months. An order to leave their residence for 2 months, and an order to prohibit abusive behavior, such as requesting meeting, extremely rude or violent speech and deeds, making frequent phone calls or sending electronic messages, and so on. The violation of a protection order is a crime. The offender shall be punished by imprisonment with work for not more than 1 year, or a fine of not more than 1 million yen, approximately $12,500. Under the law, some change have occurred. Now that the expression "revere" has entered into Japanese lexicon, the media and the ordinary people use this expression when they are talking about domestic violence. So social awareness has increased. The recognition of this crime has also dramatically increased after the law was implemented. Among spousal bodily injury cases, more than 90% were committed by the male partner or husband. The number of these cases in which police made arrest has continued to increase, reaching 1,339 in 2008. Of course, this increase shows that victims have not hesitated to report to the police, and that the police also tend to accept those reports. Before the law, it was not uncommon that the police denied accepting a report made by the offender's female partner or wife. This was because both the police and society considered domestic violence as a private matter, such as a spousal quarrel. The number of domestic violence cases which police dealt with also increased every year. There is other data collected by the Gender Equality Bureau of the Cabinet Office that shows that positive change of social awareness toward domestic violence have occurred. All prefectures have spousal violence counseling and support centers. The number of clients at the centers have increased year by year to about 68,000 in 2008. It is important to know that more than 99% of the clients are women. The center offers temporary and emergency accommodation to the victim, not limited to those of domestic violence, and accompanying children. In 2007, the number who stayed at these centers was about 6,800, with about 5,500 accompanying children, family members, and among them, about 70% came there because of domestic violence. With respect to today's theme, I will explain another law relating to domestic violence. In 2000, 1 year before the issuing of domestic violence law, the Prevention of Child Abuse Act was enacted. In my talk, I called this the child abuse law. After enacting the domestic violence law, child abuse law was amended, and an article concerning psychological damage caused by domestic violence was added. The law expanded the definition of psychological abuse by adding to it the witness of parents' domestic violence. Therefore, a child who witnesses his or her parents' domestic violence should be treated as an abused child. However, child victims of domestic violence have been somewhat neglected and need more attention. The definition of a victim of domestic violence law is limited to a spouse. This law has only one article about children. That is an article of protection order in which the abusive parent is prohibited from approaching the child who is with the abused mother. Now I'm talking about the custody issue. When a mother decides to divorce her husband, the crucial issue is whether or not she will be allowed custody over her children. In the Japanese context, most abused mothers take their children with them before divorce. In Japan, about 90% of divorces are settled outside of the courtroom. This is called a mutual divorce agreement notification, kyogiriko. This means that the decision of child custody is made without the intervention of the court. So there is no court procedure for a mother to take a child with her before divorce. Before the end of World War II, Japanese family law was made based on the clear patriarchal notion of the family. This means that children belonged to the father, and that the divorced mother was never allowed custody of her children. Therefore, she had to leave her husband without her children. In that legal structure, there is no doubt about child custody. After the end of World War II, Japan changed its constitution to guarantee every person basic human rights, and sex discrimination was prohibited. Following the change of the constitution, family law was amended to align with the constitution. The divorce procedure also changed, and a new rule of child custody was introduced to family law. As long as marriage is maintained, both parents have equal child custody. The father's single custody changed to both parents' joint custody. However, when it comes to divorce, the law asks the parent to decide which one assumes child custody, and this is the only legal requirement for divorce. The law does not accept the idea of joint custody after divorce. After the amendment to the family law, society still considered that children should belong to the father, and therefore most custody right went to the father. But later, this social recognition gradually changed. After the mid-1970s, mothers gradually took child custody when they left their husband. This change occurred for several reasons. One is that women were given more education because the Constitution gave them equal opportunity to to receive education, and as a result, they entered into the workforce and gained economic power to support to some extent themselves and their children. The other reason is that the family structure changed into a smaller nuclear family. So fathers could not raise children without their living grandmother's support, which was very common in the era of patriarchal family law. In most divorce cases, especially cases caused by domestic violence, mothers want to get child custody, so lawyers usually advise them to take their children with them when they leave their husband. Taking children without the consent of their father as preparation for divorce is not legally considered as child abduction in Japan. This is common practice, especially in divorce cases related to domestic violence. The reason why a mother takes her children with her before a divorce is that it is difficult for her to later get her children back and win custody of them if she leaves them with her husband. One of the principles by which the family court decides child custody is the theory of continuation. This is explained by the opinion that it is better for a child not to change his or her living circumstance except when problems exist. In the opinion of legal practitioners in Japan, it is not realistic to require an abused mother to negotiate with her husband over child custody. Domestic violence occurs as a result of the power imbalance of a couple. From the outset, it is obvious who will win a custody negotiation, the father. As I said before, in Japan, about 90% of divorces are settled outside of a courtroom. This procedure is allowed for couples with children under the age of 20. Therefore, 90% of divorce cases are usually settled without the intervention of courts or lawyers. After surviving the ordeal of domestic violence, abused mothers living with her children face other predicaments. We have very few policies which support those mothers and their children. So, what is the reality of mothers who leave their abusive partners or spouses? In 2006, the Gender Equality Bureau of the Cabinet Office conducted a nationwide survey on the situation of victims of domestic violence who left their abusive partners and tried to live on independently or who lived by themselves. The result was astonishing. 93% of the respondents had a child or children. The average number of children was 2.1. Almost 90% suffered from psychological violence. About 19% were victims of physical violence, and about half were victims of sexual violence. Among them, about 1/3 did not see doctors when they were injured. Only about 30% obtained protection orders, and about 60% did not apply for them. About half of them went directly to a public shelter after they left their residence. And one in five were working in regular employment, and less than half were temporarily employed. 2 out of 3 were living on an income of less than 150,000 yen, approximately $1,900 per month. This amount included social welfare allowances and is considered below the poverty line. In the same year, the average income of female employees in Japan was 226,000 yen, approximately $2,825 per month. In the survey report, respondents pointed out the obstacles they faced in starting a new life. More than half of them said they did not have enough income. They also said that they wanted to work in places which could understand their trouble with working and raising young children. They also wanted to have daycare services available while they are seeking jobs. In Japan, parents are allowed to apply to public daycare centers or nursery service only after they actually secure the job. If a mother luckily managed to put her children in a public daycare center, the cost of the daycare center is calculated based on the total income of both her husband and herself, unless their divorce is settled. If her husband earns much money and she earns very little, she has to pay a huge fee. It is common for an abused mother not to get enough financial support from her abusive husband. She can make a petition to the family court to order her husband to provide support for her and her children. According to the report, it is not easy for abused mother to go to a family court, and it is a time and energy-consuming process. Of course, courts only open during usual business hours from 9 to 5 and only on weekdays. Mothers who work at part-time jobs are usually paid on an hourly basis. This means that when they go to court, they surely lose some of their expected income. The mothers are in limbo. Abused mothers have few resources, especially when they live far from their relatives. As a practitioner, I have dealt with many domestic violence cases for more than 35 years. Before 1992, I did not know the concept and the expression of domestic violence, but many divorce cases were actually related to domestic violence. From my experience, I can tell you that mothers who are victims of domestic violence always face severe financial difficulties. Their struggles have deepened, especially in the recent years of economic decline. As the report shows, many of them have a low economic status. It is reported that 1 out of 7 Japanese children, about 3 million children, live below the poverty line. Many children abused by their fathers are among these poverty-stricken children. The report also stated that mothers need counseling services for their children. The child abuse law stipulates that children who are subject to domestic violence are psychologically abused. However, the centers operating under domestic violence law and other shelters do not offer enough counseling to those children, mainly due to budget shortage. Only 18% of those mothers had their children counseled at public child consultation centers, and 15% said that they did not know those services were available. So what is the reality of children who live with their abused mothers? One, the responsibilities of the government. Article 2 of the Domestic Violence Law declared that the national and local public entities were responsible for the application of the law. It requires those governments to provide appropriate protection for victims. According to this requirement, a national basic policy and prefectural basic plans were made. With respect to children, the basic policy of the central government stipulates that 1. Those children should be given appropriate support at schools or daycare centers for their everyday life. 2. Because those children staying with their abused mothers in shelters could not attend their nearby school due to security reasons, it is preferable for shelter to offer those children appropriate opportunities for education with the support and advice from the local board of education. 3. It is crucial for mothers who want to provide those children with necessary support for education or care. For this purpose, local boards of education should offer necessary procedures which respond to the situation of victims. According to the national basic policy, each prefecture issues its own basic plan. For example, Shizuoka Prefecture, when I am living, issued its plan for 2009 to 2013 as for issues concerning children. The prefecture made plans as follows. 1. The prefectural shelters must provide a study room and a nursery room. Before the plan, it did not have those kinds of rooms because the shelters were originally established for women and girls who were on the verge of being trapped into prostitution. Then, under the domestic violence law, these facilities expanded their function to offer shelter for victims of domestic violence. 2. The temporary and emergency shelter does not allow accompanying children to attend a nearby school, so it provides those children with an educator who is a retired teacher and who works on a non-regular basis. 3. It refers those children with mental or psychological problems caused by domestic violence to a child consultation center. There is a basic time limitation of 2 weeks to stay at a temporary emergency shelter, though this is not always strictly applied to all users. This time limitation, combined with security reasons, hinders the children from transferring from their regular schools. After 2 weeks of staying at the temporary shelter, abused mothers and children need to move to public or private accommodation. In those cases, usually the support of an educator in the shelter is not available to them because of this situation regarding education. Some mothers with children who are students decide not to stay at a public shelter or sometimes opt to stay with their abusive partners or husbands. I'd like to turn to the child abuse law. Article 13, Amendment 2 of the Child Abuse Law stipulates the following. The central and local government should establish the necessary policies for abused children to be given 1. Enough education according to their age and potential, and 2. Support to make their life independent in giving them accommodation and measures to study at high school and to receive higher education. This sounds very promising. I inquired at my prefectural office concerning their policies based on the aforementioned article, especially for children who are victims of domestic violence. They said that there is no such a policy, and they also said they did not know such a policy was made by the central government. It seemed to me that the child abuse law mainly focuses on abused children with physical, psychological, sexual abuse or neglect not caused by domestic violence. The structure of the protection of abused children is mainly designed for children who are living apart from their parents, such as those in a child shelter or foster home. I think that we need some consistency between the domestic violence law and the child abuse law, and to rethink what regulations and policies are really needed for child victims of domestic violence. Now I'm going to talk about good examples for child victims of domestic violence in private shelters. I read a report about a project specially designed for these victims in a private shelter. It is titled Research and Study on Child Abuse Concerning Users of Shelter, run by HELP. HELP stands for House in Emergency of Love and Peace, and it was established in 1986 as a shelter for both non-Japanese and Japanese women and children. HELP started its original child care program with private grant in 2001, the year of the implementation of the domestic violence law. From 2004, they hired staff members who were trained for child care programs. It evaluated its program of 2006 by interviewing mothers and their children and then compiling the result into a report in 2006. The result shows that the main users of the shelter were Filipino women married to Japanese and their children. Other users were women from Central America, also married to Japanese and their children, and Japanese women and their children. All users fled from their Japanese husband violence. children whose mothers brought to the shelter ranged from babies to junior high school students. The duration of their staying was about 2 weeks, which is similar to a public shelter. Most children were physically abused by their fathers while they lived with them. The total number of children who participated in the program was 20, and 16 of them witnessed their fathers' physical and/or psychological violence against their mothers. Some older children intervened between their parents while domestic violence took place. The contents of the program included everyday play in and outside of the shelter building and a large outdoor space, support for education, including art therapy, Japanese language, dance therapy, and special farewell events for children leaving the shelter. They have trained staff members who work on a regular basis. In addition to these staff members, they have other staff members who work on a volunteer basis. This system helped the children study their school curriculum well. Two of the important tasks of the educated in help were to help them to enjoy of studying and to evaluate them well by focusing on whatever they did well. According to the report, children began to realize their potential and regained confidence in themselves and restore their own dignity. The report pointed out an important thing that was achieved by young male volunteer staff members. Usually a shelter does not have male staff members because female victims think they do not trust any male as a result of their experience of abuse by their male partners. Children there also did not know the meaning of a good relationship between both sexes. They were exposed to violent relationships between their parents, and as a result, they only learned about the unhealthy relationship constituted by their power imbalance of their parents. They needed to learn about healthy relationships between both sexes, in which equality exists. The existence of actual male staff members whose behavior is different from the children's fathers teaches those children that man is not just violent and that he should not control his female partner. Their existence simply shows children an alternative way of being a man and that a man is not always dangerous. This will help children get an alternative perception about a man and the quality of relationships between both sexes. When I read this report, I remembered my visit to a shelter in Madrid in 1998. I was deeply impressed by the policy of education for accompanying children at the shelter. Like other shelters for victims of domestic violence, abused mothers and their children stayed there. The shelter had educators that constituted of a pair of both sexes. The director of the shelter explained to me that the reason they had those educators, especially the presence of the men. She said that children there needed to know a positive relationship which was completely different from their own experience in order to stop a chain of violence in their future. The best way to teach children was to show them an actual good relationship in everyday life. The child care program at HELP did the same as the shelter in Madrid, and it worked. Child care program gave those children comfortable circumstances, and it got rid of the pressure which their abusive fathers had caused. And as a result, children regained their power to live as well as their mothers. After a two-week stay there, they were ready to move out from the shelter and to start a new life. I'll show you other examples of child care programs run by other private shelters. An NPO in Hokkaido, a northern part of Japan, called Masakane. It started child care programs in 2005, and it was awarded a grant from a public organization in 2008. And with that grant, it started the program of daycare services for women and their children who survived from domestic violence. they rented a house of 2 stories. The first floor was designed for the children, and the second floor was for mothers. They offered various programs for children and mothers who had moved out from temporary shelters. They offered childcare program for 2 hours per week. Children played and studied art therapy, music performance, and book reading. They also provided them with transportation. The staff members, mainly students of nursing schools or other schools, were working on a volunteer basis. They also realized, while supporting children, that it was similarly crucial to support their mothers in order to help the children recover. In many cases, abused mothers were exhausted and fatigued physically and mentally from the violence of their husbands. They also offered to the mothers program of cooking, art, IT skills, and the method of self-evaluation. In the process of taking the program, mothers regained their ability to live independently and raise their children properly. These programs worked. Another NPO, Women's Net Saya, reported a similar successful experience. They began their activities in 2000 and started specially designed programs for women and children who are victims of domestic violence. They offered a psychological support program for children called BeLove, with 4 stages based on the age of children. Their clients are mothers and children living in communities after leaving shelters. They offered mothers program to support their job seeking, such as learning IT skills. According to the report, while taking the program, children found that they are not alone by sharing their abusive experiences and finally changed their perception toward themselves and regained their will and energy to live happily. I'd like to positively evaluate these good outcomes made by special programs focused on the needs of child victims of domestic violence. And I'd like to urge the central and local government to allocate appropriate budget to those programs. It is important to avoid a chain of violence in future generations, and more importantly, to make a difference to victims, mothers and children of domestic violence. Now I'm going to tell you another side of the reality of abused children in domestic violence. There was a report made by the National Women's Network of Shelters in Japan in 2009. Most private shelters and activists for domestic violence throughout Japan are members of the network. In 2007, with a public grant, it conducted a survey on sexual abuse of children who left with their mothers from their abusive parent. They conducted the survey by reviewing the records of the experience of sexual abuse among women and their accompanied children attending public and private shelters from 2001 to October 2008. They also conducted hearings from staff members and volunteers of those shelters. Their motivation for this survey was that in recent years, some staff members recognized that there was an increase of severe sexual abuse among children at shelters. In most cases, the abuse came from their fathers. They wanted to know the fact. The result of the survey confirmed their surmise. The number of children's sexual abuse cases has increased during the time framework of their survey. In 2000, although the number was 10 months, about 6% of children who were raised in domestic violence families suffered from sexual abuse. The number of children who suffered from sexual abuse in 2006 was 3.1%, according to statistics collected by all child counseling centers in Japan. The percentage of 6 showed a higher risk of child sexual abuse in families with domestic violence. It can be supposed that the total number of all women users of temporary shelters of victims of domestic violence could be about 6,800 per year, and that of children could be almost 6,000. These numbers were calculated based on the statistics of the Ministry of Health, Labor and Welfare, and the numbers came from private shelters. From these statistics, we can also suppose that about 350 children were sexually victimized in their families, mostly by their biological fathers. If we do not limit the number to temporary shelters, there clearly would be more victims. The report emphasized 4 points as follows. 1. 25% of children who were sexually victimized already experienced other types of abuse, such as bullying in their schools and repeated sexual abuse. It concluded that experience of any abuse made children more vulnerable to sexual abuse. 2. Among the victims, the youngest was a 1-year-old baby. Young children could not understand what happened to them, and therefore could not report their victimization to adults. So the report concluded that it is necessary to give sex education to children early and find out about sexual abuse early. 3. There are very few experts dealing with child sexual abuse, so most victims could not get appropriate treatment. When staff members of shelters found out that their children had been sexually abused, they did not refer them to the appropriate place for treatment. 4. Most abusers were their biological fathers. If the statistics included other male family members as offenders, 100% of offenders were family members. Now I'm talking about the cost of child care support. As I mentioned, many abused mothers are struggling with severe financial difficulties. With respect to expenses for child support in Japan, I must tell you that it is inadequate. The general situation of this issue is dreadful. In Japan, the legal requirement of divorce is only to decide child custody, so making an agreement of child support is not legally required. In addition to this, 90% of divorces are settled outside of the court. As a result, only about 31% of mothers who divorced outside of the courts have agreements of child support in 2006, according to the survey conducted by the Ministry of Health, Labor and Welfare. About 80% of the mothers who divorced through court procedures have agreements of support. However, according to the survey, only about 20% of the divorced mothers actually received support. There is a trend in which the longer the woman has been divorced, the less support the women received. This showed that among fathers who made agreement of support, only some of them continued paying for the period of the agreement. There are two problems concerning financial support. One is that even when a mother initiates court procedure to ask a father to pay support, the court only orders the father to pay a small amount of money. There is a standard which now all courts rely on to calculate the money. This was made by a group of judges in 2003 to save time and energy for courts and parents with complaint. However, it turned out that the result is insufficient for mothers and their children who live with them. The reason is that the standard allows a parent to keep about 60% of their income before calculation, and therefore the remaining 40% is the basic amount with which to calculate support. Usually the father earns much more than the mother, so he can keep much more money. This formula is partly based on the data from which public welfare money for children is calculated. As a result, for a mother and her children, they surely become poorer than they were at the time living with their father. This system severely discriminates against abused mothers and their children. The average income of single mothers in Japan in 2000 was about 2.12 million yen, approximate $26,500 per year. I told you that 2 in 3 mothers who left their abusive husband had monthly income of approximately $1,900, which is approximately $22,500 per year. And this is below the average income of single mothers. Some practicing lawyers, including myself, who are concerned with these injustice practices, have just started to argue for change. The second problem is that fathers in fact are allowed not to pay. There is no punishment for fathers who do not pay. Only when a mother obtains an agreement through a notary public or a court order for the payment, she can ask a court to force a father to pay. If he has a sizable and sizable amount of money or property. The problem is that for an abused mother to take such court action is not easy. Now I'm talking about the visiting right. There is no article in Japanese family law about visiting right, but in the mid-1960s, the Tokyo Family Court first acknowledged that a parent without child custody had visiting rights. Since then, these rights have been recognized in family courts throughout Japan. The difficult question occurs when problems of domestic violence are revealed. Abusive fathers demand their visiting rights. In the case of domestic violence, usually abused mothers with custody of their children refuse to accept those demands. Now that the negative impact of domestic violence on children is being recognized, lawyers dealing with domestic violence cases urge family courts not to allow visiting right to abusive fathers. Some judges understand the dangerous and negative impact of abuse on children, but some judges do not. We do not have special public services in which experts can supervise visits in high conflict cases. In addition to this, district courts and family courts work separately in case of domestic violence. The problem is that the district court issues a protection order and the family court orders visiting rights. They cannot exchange information on petitioners of visiting right who have been served with protection orders. So a family court can accept a petition for visiting right applied for by a father with a protection order which ordered him not to approach his children. This is a contradiction. I experienced such visiting right cases in which the conciliators are male and female, both of whom are ordinary people, tried to persuade my client to accept the father's wish to see his children by saying that he loved the children very much. He had been served a protection order which prohibited him from approaching his wife and children. I submitted a copy of protection order to the conciliators, but they still tried to persuade us to change our minds. This is one of the difficult realities in our legal system. In conclusion, last year, the National Women's Network of Shelters in Japan held an annual meeting. They invited Randy Bancroft, an American expert on the impact of domestic violence on children and families. He gave a keynote speech in which he pointed out that the most ignored issue in the context of domestic violence was the issue of children. In Japan, we have had experience of dealing with domestic violence legally and socially for about 19 years. It is time for us to intentionally turn our focus to the child victims of domestic violence if we wish to aim to create a society where everyone can live safely, peacefully, and with equality. Thank you.